is Kiati. I'm head of Joshi Advocates. Thank you very much for joining us in our Christmas edition Home Office policy on good character for British nationality applications. In the next 5 minutes, we will see the change that has been going around. Thank you very much for your calls and your emails to ask whether the 10 years still applies in respect of good character. Now, spoiler alert, the 10 years is still there, but it's a bit more limited in its capacity to refuse the application. So in the next 5 minutes, we will see technically where the Home Office still has kept that power to refuse us under 10 years and where they most likely will not refuse the application. All right, so first, now Home Office saying that whoever applies for British nationality must have 5 years of lawful residence. That means we need to be legally living in the UK for 5 years. Right. Now, in those 5 years, there should not be any immigration law breaches, no overstaying, no running away from the Home Office, absconding, so failing to sign with the Home Office or coming in the UK illegally in those 5 years. Now, and Home Office saying that the immigration law breaches in lawful residence in the 5 years would not be considered, would be disregarded. So they will still consider it, but they will be disregarded. Home Office caseworker policy in the description box below. I've linked the link there and given the page numbers. So Home Office saying the caseworker may disregard immigration law breaches such as illegal entry, overstaying, absconding in the 5 years of lawful entry if 1, all the 3 conditions have to be met. So 1, the person makes application for nationality by registration after June 2022. Tick. The person has indefinite leave to remain. Tick. And there are no serious concerns after being granted indefinite leave to remain. Settlement. So if the applicant says in the 5 years no immigration law breaches and application is made for nationality by naturalization after June 2022 and the application has an indefinite leave to remain as a settlement and there are no immigration law breaches or serious concerns regarding conduct or behavior in those 5 years. So we don't want any criminality in the 5 years, for example. Now imagine there's criminality. Imagine there's like a fine or something like that in the 5 years. Then Home Office will say, yeah, we still have the power to refuse application or we don't. So remember, this is a may. Home Office may disregard. They don't have to. May allows the word allows the Home Office power to refuse application. Now, if there are convictions or anything like that, that is separate consideration under the rehabilitation section of the Home Office policy on good character. This video is just going to consider the good character in respect of immigration law breaches during the 5 years or 10 years. So let's say if the Home Office is saying in the 5 years the person is clean, the policy still says the caseworker must consider any immigration law breaches in the 10 years. Now, even if the caseworker said, okay, 5 years is clean, we are going to disregard it even if it's not. So box ticked, application could be successful because that condition is met. But the caseworker's policy states that the caseworker must go on to consider. So the caseworker must still also consider what's happening in the 10 years. So this is where the 10 years is still in play. The caseworker still must consider what the conduct is like in respect of immigration law breaches in the last 10 years. But this is where the limitation is. The caseworker in respect of overstaying must not refuse the application solely on overstaying in the last 10 years. If the person, again, has indefinite leave to remain and there are no serious concerns regarding conduct after being granted indefinite leave to remain. So if you meet, for example, the 5 years of lawful residence, indefinite, clean character in the 5 years, and you had overstayed at some point in the last 10 years, then the caseworker cannot refuse application solely on that point. So that's the beauty of it. So well done. I'll give an example of this. For instance, say you came in 2012, we're in 22. So say you came in 2012 and with a visit visa, you overstayed. 2015, you married a European national, you got the residence card. 2020, you have permanent, and then EU settlement scheme, settled status. 2020. That means 2021 onwards, say December 2022, you make your application. Home Office will not refuse it solely on the basis of overstaying from 2012 until 2015 for the 3 years, even though it's in the last 10 years of the date of the application, unless there are other character differences, which is separate. But as far as the good character is concerned for immigration law breaches, it would not be refused solely on overstaying in the last 10 years. Now, also illegal entries. Home Office does not want illegal entry in the last 10 years of the application. Again, this could be explained with why the person entered illegally and when they first came to know the Home Office. But again, Home Office would want, although they came to the Home Office knowledge in 2012, for example, they didn't have lawful residence. So Home Office might be on the fence on that one. So when you have a good character point like this, seek to persuade the Home Office with an explanation on why the policy allows you to still be successful and meet the good character requirement. I hope this has been helpful. I know it's technical, and I hope that I've explained that the 10 years is a bit more limited now. So your application should be successful. If any questions, as always, contact me, details below, subscribe, and I will see you in the new year 2023. So wishing you a very, very, very Merry Christmas and a Happy New Year. Thank you so much. Take care.